Welcome to the Power of Offense with Keith and Rodney. And today we're going to discuss a show that was published by attorney Dennis Spurling. And for the record, I am a subscriber of Dennis Spurling channel. And I think that Dennis Spurling has some dope content, which led Rodney to calling in to one of Dennis Spurling's shows, of which we're going to discuss today. Now, just to let everyone know, right, we are going to criticize and critique this conversation, right? But our intent, or let me make this clear, our intent is not to attack Dennis Spurling personally. It's not to bash the brother or anything. We just want to deal with the content of what he was saying. You know what I'm saying? So we're not against Dennis Spurling, not at all. We just want to deal with what he was saying in this particular show, where he was talking about the expansion of police authority. Now, Rodney was attempting to explain to him the benefit in using the 1866 Civil Rights Act in relation to the expansion of police authority, but that conversation didn't go as well as we planned. You know what I'm saying? So I guess from here, Rodney, you want me to just play the clip?
You might as well.
All right, so here we go, y'all. Fair use, fair use.
Either way, Rodney, go ahead and wrap up, and then we're going to go to Ricky and let him finish. What are your thoughts?
Okay, yeah, well, I'm not sure what part I keep getting cut off on, but I was talking about the difference between the United States Code, which most of us use whenever we want to sue a public official, i.e. the police department. And I was trying to explain the difference in the United States Code, which it kind of invokes the immunity, which is what everyone is talking about. But there's a law that immunity can't touch, and it's in the statute at large. So I was asking, was anyone on the panel, have they ever heard of the Act to Protect All Persons in the United States in their civil rights and a means to furnish their vindication? That's the name of the law. So have anyone heard of that law on the panel?
Well, they're not answering questions. Go ahead and tell us what you're going to say about that law if you want to
answer. Okay. Well, anyway, that law was the Civil Rights Act that they passed right after the Civil War. It's a statute at large.
You mean the one in 1865?
66. So yeah, most people know it.
What was that guy from California? He ended up suing like some major corporation. A black dude with the TV shows, used to be a comedian.
Yeah, Byron Allen, but he used it wrong. So Byron Allen. Let me tell you a little bit about.
Tell me how that relates to what we're talking about right now.
It relates it relates all the way to it, because I'm not going to talk about Byron Allen right now. I would talk about what I'm talking about, which is that law. So if you're familiar with the Constitution had a supremacy clause. If you Google supremacy clause, it's going to be the Article 6 of the Constitution, and it says this Constitution, the laws of the United States, treaties that was signed, that may be signed, is the supreme law of the land. That's what it says, and then it has a clause in it.
Federal law supersedes state law. That's what that's saying. So you can
it's saying what?
You can have a state law that's stricter, but it can't be. The federal law supersedes state law. Period. That's basically.
But it's saying it's the supremacy clause. It's the supreme law of the land. So the language that's in Article 6 that makes it.
There's articles, brother. There's also other articles that say anything that we don't govern is left to the state.
Well, I'm about to cap all that up. So if you don't raise your rights, you waive your rights. So whenever you're using the clause that I'm talking, the language that I'm speaking of in the Article 6 of the Constitution, because you have to at least start there, because that's the supreme law of their land. So, and the clause that I'm speaking of, it says any law to the contrary is notwithstanding. That makes Article 6 and
mixing and matching a lot of different concepts and a lot of different legal precedents, and there's a lot of
no, I'm not. I'm actually speaking of just the Constitution.
Sir, I'm a lawyer. I've been practicing law 21 years. I have an LLM in law, not just a JD, but an LLM. And I'm telling you, you're mixing and matching. But we want to focus on this particular Supreme Court case, the Rivas case, and the Fourth Amendment, and your thoughts on that. We don't need a dissertation in the law. We just need your thoughts on it based on what
I appreciate your time.
Sir, You don't have to explain all the background. Just give us your conclusion. Go.
Well, I don't have a thought on what you're talking about because the Fourth Amendment doesn't apply. I understand that you
And the Fourth
practice law.
Amendment doesn't apply to who?
What you're talking about. If you're talking about civil rights case and being whooped by the police and how to defeat that, I'm not learned in law, but I don't want to take up any more of your time because you keep cutting me off. So you can go in with your show, but
I'm cutting you off because like you focus on.
No, I'm focusing on trying to school the people because you're an attorney, so you don't understand the law that I'm actually. Have you ever heard of that law? And now you're talking about the Fourth Amendment, but I don't want to hold your show up.
I talked about Byron Allen and how he used it.
He used it wrong. He used it wrong, but he used it in a way that brought up the Article 1866. But I read his case. I read the opinions from the state level and the federal level, and he used Title 42, 1983, because that's the language that they picked out of the law that I talked about to make Title 42. So, but again, I don't want to go back and forth. Y'all guys have a nice day.
All I'm saying, see, I hear what you're saying, but like you got to give us a conclusion, you know, and like I'm not gonna let people just ramble on and speak, and because you
I'd already hung up.
Different legal concepts.
Yes, you did. I just wanted to get to the part where he said that you're mixing legal concepts. According to him, this is what he's saying. But I just want to say this real quick, Rodney, that Rodney and I have talked about this in the past several times. It is important, y'all, as laymen, that you know the law for yourself, because ignorance of the law is no excuse, not for Attorney Dennis Spurling, right? Not just for him, but even for us. You got to know the law, and Rodney is going to break down to you all what he was trying to explain to Dennis Spurling.
Right. You can tell he's a lawyer because he'll try to take bits and pieces. What he do, he cherry pick what you're saying to better his position. So that's pretty much what he was doing. At first he was saying that let's talk about the act that I was speaking of. And then he said, well, let's talk about the Fourth Amendment. And then he said, let's go back and talk about the 66 Act. So he was kind of going back and forth and doing a brilliant job of cutting me off. But the point I was trying to make was, whenever you deal with Title 42, 1980, 1, 2, 3, 4, 5, 6, that's the United States Code. And the law that I was speaking of, which is the Act to Protect All Persons in their civil rights in the United States and the means of furnish their vindications, is a statute at large. The Supreme Court says that there's a variance between the United States Code, which is Title 42, and the statute at large, which is this law on the screen, that the statute at law control, meaning that the statute of law, the law that I'm talking about, controls what the Title 42, which all of the attorneys are taught to use, which is defeatable in court all day long unless they want you to win. And then I was trying to let them know that the Constitution, how it says it's the supreme law of the land, he tried to water it down by saying federal law trumps state law. But it's you didn't play the part where he said that there is no supreme law, something like that. But
No. With that one, just to let y'all know, we're going to do a separate video to deal with that, where he actually said that. Yeah.
Right, but the language specifically in the Article 6 that I was trying to mimic was anything to the contrary is notwithstanding. I mean, anything to the contrary of the Constitution is notwithstanding. That's why they call it the supreme law of the land. That language right there. So whenever they lost the Civil War and part of the 13th Amendment, when they enacted it, they provided language for Congress to enact other laws to support and give more strength to the 13th Amendment, which was this act right here. And this act right here clearly say that anything to the contrary is notwithstanding. Any law, statute, ordinance, regulation, or custom to the contrary is notwithstanding. Meaning this is, you can call it the Black Constitution. You know what I'm saying? Because they're talking about slavery. They're talking about those who were in involuntary servitude, which most of the time it was us, and those who were convicted of in prison time. So, but we talking about the slavery piece. We're not talking about involuntary servitude because we didn't volunteer for anything. Right. So whenever they gave this law, they said anything to the contrary is notwithstanding. So if it's good for them, the Constitution, the supremacy clause, the supreme law of their land, anything to the contrary is notwithstanding. That means when they pass this law, anything to the contrary of this statute of law in 1866 is notwithstanding. That means this law here is bulletproof. That's why it's hidden, buried away in the Library of Congress and in the National Archives. And what they did, they cherry-picked bits and pieces of it, created the code. The code is a watered-down version of the law. That's why the Supreme Court says that the United States Code is controlled by the statute of law. So when you have a United States Code, you need to go to where the statute of law gave its rise to and get the real law to use to make it more concrete. So all these games that everyone is playing, all the lawyers, the Congress, and everyone is playing, talking about the Voting Rights Act, the 1964 Civil Rights Act, is all bullshit. You know, all they're doing is wasting our time pretty much because they know, or they ought to know, that this law exists and it helps to have a stronger case when those who don't bring their own cases and they rely on attorneys that can bring a strong case. And that's why I keep it saying ignorance of the law is no excuse, because if you have a civil rights matter, you should know the rights yourself in order to guide your attorney to win. You know, so if they don't want to do it, you have to find an attorney that would do it, because all this Title 42 is a watered down version of the law that will create controversy enough in the federal court and in the state court to where you'll win almost every time if you can prove your facts.
Absolutely. Now, just a fun fact, right? And this backs up what Rodney say, because what can be proven must be proven. And here at the Power of Offense, we always prove what we say. So like Rodney said, Title 42. So here we go, 42 USC Section 1982, right? The right to acquire, hold, convey property, It says it was originally established by the Civil Rights Act of 1866. Now, the interesting part of what Rodney is saying is that when you use those codes, right, those codes actually leave out information that's in the act. So why not just use the act? Because you have choice of law. Why not just use the act? Exactly. It makes sense to use the act.
Because nowhere in Title 42, 1981, 2, 3, 4, 5, or 6 does it say anything to the contrary notwithstanding. That means immunity is withstanding on Title 42, but it's notwithstanding when you use the act. They can't say, well, I was doing the course of my job, so that's why I shot him in his head 3 times. They can't hide behind, well, I was doing my job, so I ruled against him because I didn't want him to win against somebody else, or whatever the case may be. They can't use immunity whenever they violate your rights according to this law.
Absolutely.
You know, I'm not saying it. The law just explained it.
Absolutely.
You know what I'm saying? And inside the case law, it explains it even further. But when you come in with Title 42, it strips that bulletproof. In other words, you're taking off the bulletproof vest and you're putting on a hoodie. You know what I'm saying? You're going out to battle in a hoodie as opposed to a bulletproof vest when you come in the law using Title 42. And this is what the law is clearly saying. However, the brother Spurling, he doesn't know any better. So he know not what he do. I'm not really mad at him for real, because he explained he was a lawyer for 21 years and he learned from our oppressors. So do you think our oppressors will teach lawyers law to free and emancipate us? Hell no. But will Rodney and Keith go and study thousands of hours in the Library of Congress, in the law library, at the National Archives, to co-find the law where these laws come from to give us a better opportunity for free? Yes. We're not charging a penny in order to help you help yourself. But it's attorneys like that are so arrogant, like what's his name, Spurling or Sterling?
Dennis Spurling, yeah.
Spurling, yeah, like Spurling. I've never met an attorney that didn't think, one, they were smarter than us. I never met an attorney that, especially when you start talking about law, they start bringing up their resume. I don't care about your resume. I care about wins for our people.
Absolutely. And I like how you put that too, Rodney. Now, another fun fact, I wanted to end with this too, is that the Civil Rights Act, right? It was, now I'm going to read what it says. It says the 1866 Civil Rights Act, which the Supreme Court found to be a constitutional exercise of Congress's power under Section 2 of the 13th Amendment. Basically, the enabling clause of the 13th Amendment is what produced the 1866 Civil Rights Act. So the Civil Rights Act is as, how can I put it, as pure in intent as you're going to get to the 13th Amendment.
Can you quickly show them the Section 2 of Article of the 13th Amendment?
Sure.
Can you pull it up right quick to show them what it's saying?
Yes. Section 2, y'all. Right here. 13th Amendment. Congress shall have the power to enforce this article by appropriate legislation, and the appropriate legislation that Congress found to use was the 1866 Civil Rights Act.
Period. It was not Title 42, anything. It was the Civil Rights Act, and they put in a supremacy clause for us to use. They said neither slavery nor involuntary servitude except as a punishment for crime, whether the party was duly convicted. See, the word duly is key. You know what I'm saying? Most of us are not duly convicted. So this right here is clearly telling you, right back to the law, it doesn't matter your condition of slavery or voluntary servitude, except as punishment. They give you the 13th Amendment, and then it also tells you the power of this law, because any law that you make, which is any statute, any ordinance or regulation or custom, is contrary, notwithstanding. If it's to the contrary of this law, it's notwithstanding. That means it doesn't hold water. That means this law is bulletproof if you use it. And it gives you jurisdiction. It gives you everything you need. We're not going to go through the whole law, but it gives you everything you need to formulate your case and go attack, state or federal level.
Absolutely. So y'all let us know what you think. You know, please drop us a comment in the comment section. Give us a like, share this video, and we'll catch y'all on the next one. Peace. We out.
Peace, peace, peace.